Um, and I'm kind of befuddled about that. Why would you get an email from, I mean, getting an email from an attorney is about as unsettling as getting an email from the IRS. And I wouldn't think you would just simply say, yeah, I'll open it later. Like, go ahead, I'll listen to you.
Yeah, when I said I did not open, so I opened the email the evening of June 27th. When I looked at the email, it was dated for June 25th. So I didn't open it on June 25th. You can see from probably email records of when I opened the email, but it was on the evening of June 27th. I'm been working in the late afternoons and I had my kids that day, the day before. So again, I didn't open it till the evening of the June 27th. As soon as I did go to the court the next day. And well, first I was trying to find an attorney to get legal counsel, and I was having a difficult time doing that. And then so I went in to try to ask as soon as I could to ask for an adjournment, which wasn't able to do the first thing Monday morning, the following Monday morning. And
Um,
trying to get legal counsel for the past.
All right, guys, let's start strong. The judge opens this hearing already puzzled. He can't believe the father ignored an email from an attorney. He compares it to ignoring a message from the IRS. You just don't do that. The father tries explaining he was busy with work and kids, but the judge isn't buying the excuse. The room feels tense already. One side claims delay, the other claims misunderstanding. You can feel the storm brewing before the real issues even start.
3 days, and because of the short holiday week and just such short notice, I wasn't able to obtain legal counsel.
so one of the things I did notice because I wanted my uh, clerk to, I asked my clerk after I got your motion to read me off the address that the court has for you. And that was 1845 Flowers Crossing. See, that's the problem, is when you move or something along those lines, it's no fun unless you let the court know. And that was, I think that's been corrected as of now, but that's the last known address that the court had. And technically, by court rule, all the attorney is required to do is send it to you at your last known address. Can't help it if you actually get it or get it.
Now listen up. The father explains he opened the attorney's email 2 days late, on June 27th, after it was sent on the 25th. He swears he went to court as soon as he could, even tried to find legal counsel. But the judge calmly reminds him of a harsh truth: the court only has to use the last known address. Whether he read it late or not doesn't change the rule. It's a tough lesson in family court. Timing is everything.
6 days before, that's something that you really could have got it a little bit sooner than that had you opened it on the 25th, right?
Yeah, it was she sent it the evening of the 25th.
Yeah. So I'm just saying that
And because of work and then having my kids, and the next day I had work all day, and then I had my kids through the evening. I don't just check emails every day.
well, I would if I got one from a lawyer. If I get one from a lawyer,
I
or
haven't got anything from a lawyer in a long time. So
I'm with you. Well, also, your motion is not even properly filed.
well, again, I try to get legal counsel, but I'm not an attorney. I didn't know that. As soon as I had the opportunity, which was that first Monday morning, that's when I submitted for.
Here's where it gets heated. The judge points out that if the email had been opened on time, maybe things would be different. The father insists he had kids, work, and barely checks email. But the judge fires back, "I would if I got one from a lawyer." That line hits hard. You can feel the courtroom's silence as the father realizes there's no sympathy here. This isn't about excuses anymore, it's about accountability, and the judge is making that crystal clear.
For an adjournment.
Yeah, I know. I know you're not an attorney. I know you've had an attorney in the past, I believe. But with that being said, the motion's not properly in front of me. And I'm going to respectfully deny the motion to adjourn because it's not properly in front of me. So,
Well, all I can say is that, I mean, this is a very profile case. There's a lot of claims regarding the best interest of my kids. Like this is, it needs to be done at a very high level for the best interest of my kids and prepared carefully. And because of there's false accusations, there's concerns with
All right, guys, now the father's defense starts to crumble. The judge tells him his motion wasn't even filed correctly. The father, visibly nervous, says he's not an attorney and just wanted more time. But the judge isn't impressed. The motion gets denied. Boom, no adjournment, no delay. The father pleads that this is a high-profile case involving his kid's best interests, but the judge stands firm. The court doesn't care about emotion. It cares about procedure.
well, let me get you straight first. Let me get you straight first. Whose false accusations? Miss Shepard, Miss Judd, or your kids?
Miss Shepard.
Okay. All right. Okay. So
And there's a lot of again, this is a very complex matter, especially when it's pertaining to the custody of my kids. We can have a really detrimental mental health status with me potentially losing custody of my kids, and this needs to have proper legal counsel to not only gather the supporting evidence to counter her claims, which takes a little bit of time, but again to gather supporting evidence and to have proper counsel and defending these accusations.
okay, thank you. All right, let's get to Miss Judd's motion, please. I read your motion, Miss Judd. Is there anything you would like to add? I do have a few questions.
Now the father tries one last plea. He claims there are false accusations and deep emotional stakes. You can hear the desperation in his voice. He's fighting for his children, saying his ex, Miss Shepard, made false claims. But the judge cuts him off. Whose false accusations? That's when things turn personal. He points at Miss Shepard. The judge nods. He's heard this before. The father insists the case needs fairness, evidence, and time. But the law moves faster than feelings.
For you after you've said what you're going to say.
Of course, I tried to be thorough in the motion itself. I guess I wanted to just address one comment that Mr. Shepard made. I do not believe he didn't get the email until the 27th. I sent it to him on Wednesday night after my client had secured the children. And I did that on Wednesday so that the children would be with her when Mr. Shepard received the email. I'm fairly confident that he had received the email by the following night, as he had then on Thursday taken it upon himself to have the children playing a first-person shooter game, having them pretend all the enemies were NP, my client's paramour. This has escalated to a really concerning level, and I'm really worried that somebody is going to get hurt here. So I'm trying to be thorough and forthright in my disclosures. This was originally accompanied by an ex parte request, which was denied with a suggestion that CPS be utilized. But my client has utilized CPS. They've been contacted 3 times now by the child's therapist, the eldest child's therapist, to no avail. I read that myself in the therapy notes. I did not disclose all of the therapy notes. I quoted some.
And here comes the switch. Miss Judd, the opposing attorney, takes the floor. She's sharp, confident, and ready to strike. She says the father did get the email, and by the next night, he was allegedly having his kids play violent games, pretending the enemies were her client's new partner. That line alone changes the energy in the courtroom. Suddenly, it's not about late emails anymore. It's about behavior, children, and possible danger. The tension hits a new peak.
Significant portions of them, but I'm trying to respect these children's privacy. And I suspect that CPS isn't stepping in because a majority of this is psychological, less the admitted slapping that was littered throughout the therapy notes. I've got a nearly 10-year-old girl now without a bedroom, reported to her therapist to be sleeping on a kitchen floor. Something needs to change here. My client does not want to cut Mr. Shepherd out of these children's lives, but he's not participating at all in their therapy. I think this has become somewhat of a game, but these kids are suffering. These kids have now documented disorders. They are scared of him. They are being harmed in his house. And he's on some crusade here to ruin my client's life and her paramour's life at the expense of these three children who all they want to do is have a relationship with both the parents. The therapy notes were terribly sad. At such time as we have a hearing, I suspect all of this will come out. But these kids are terrified. They're terrified of the situation. They're terrified of retribution. They're being physically disciplined as a result of all these disclosures to their therapist and to my client.
Now listen to this. Miss Judd doesn't stop there. She reads from therapy notes describing how one child is sleeping on the kitchen floor and scared to go home. She claims CPS has been contacted multiple times, but nothing's been done. Her tone is furious but controlled. The judge listens intently. She says the father's anger has turned into a crusade and the kids are paying the price. The room feels heavy with accusation, fear, and truth no one wants to face.
And Judge Gottlieb has already given Mr. Shepherd a stern warning to move on. Let it go. The divorce has happened. My client has moved on. Everybody can move on and be happy. We just need Mr. Shepherd to get on that train. And I'm not sure what the roadblock is here, but I think we need to look into the root of this concern because taking his anger out on these kids is really escalating to a concerning level. I think at a minimum, we need to implement a supervision requirement until we can get into this. I think it would be imperative for him to participate in their counseling for once so he can hear firsthand what kind of psychological trauma this is causing to the kids. And I would also request verification from a medical provider of some kind that he's even cleared to drive because we've got a history of intermittent seizures. I don't know if he's being cared for properly by a medical provider. I have no idea if he even is cleared to drive. I'm not sure if he's had subsequent seizures, but like I said, I'm really worried here that somebody's ultimately going to get hurt. I would prefer that not to happen. So my client has turned to this court for relief.
Thank you. The question I have is, and it's somewhat concerned.
She demands supervision for the father's visits and questions whether he's medically fit to drive due to past seizures. She paints a picture of escalating risk, emotional, physical, even psychological. I'm worried someone's going to get hurt, she warns. It's chilling. This isn't just a custody dispute anymore, it's a full-blown crisis. You can see the judge processing every word, knowing he's balancing the safety of children against a parent's right to be heard.
When I read your paragraph 53 in your motion, I became concerned because what that tells me is that the only reason that your client agreed to a consent judgment of divorce was with that paragraph in there. And that seems to run afoul of when they raise the right hands and tell the referee or judge that this judgment is in the children's best interests. Paragraph 53 somewhat indicates that it's not, that it was only done out of convenience by your client to get this done, and I'm troubled by that.
Oh, I certainly didn't mean to suggest that, Your Honor. I was suggesting that it was important to Mr. Shepherd to have the label of being a joint physical custodian. And despite the reality of the schedule operating in a manner that had rested physical custody with my client, at such time as mediation was happening, we all just agreed to have the label of joint physical custodians with everyone being on the same page that we didn't have a joint physical custody.
All right, here's where the judge steps in again. He questions paragraph 53 of Miss Judd's motion, hinting that her client, the mother, may have agreed to the divorce judgment just for convenience, not for the kid's best interests. That's a serious red flag. The attorney quickly clarifies no deception intended, just a compromise. But the damage is done. The judge's tone makes it clear this case isn't clean. Everyone's fighting for control, and the children are caught in the middle.
Arrangement. The parenting time schedule doesn't dictate a joint physical custody arrangement. And subsequently, because of her attending the medical appointments, her spearheading the therapy, her spearheading the school activities, she really is the primary custodian. I had referenced that merely to address the burden here moving forward. I certainly didn't mean to suggest that my client had created any kind of false impression to the court. The parties were getting along a little better at that time. And like I said, in the judgment, there was intention of expanding the schedule. So it was anticipated that perhaps the parties would be joint physical custodians if Mr. Shepherd did the things that he was supposed to do. But that didn't happen, and time had passed. So the circumstances have really created a primary physical custodial environment with my client. That's what I had intended to suggest.
Also, the last question I have is, then we'll hear from Mr. Shepherd. Why hasn't, maybe he has, I don't know. Why hasn't NP gotten a personal protection order?
While the judge presses about a possible protection order, why hasn't the new partner, NP, filed one? The attorney says he's about to, but they've been trying to keep the peace. The judge isn't satisfied. He warns that if these threats are real, the children might not be truthful or someone's hiding something. The entire courtroom goes quiet. Nobody wants to be the one lying under oath, but the tension says it all. Someone's not telling the full story.
I believe he's in the process of doing that, Your Honor.
Okay.
And frankly, the answer is everyone's been trying to keep the peace, but
Yeah, that would be because I don't know about your initial thoughts, but a PPO against is it a live together partner or not?
it is as of recently, and that's what has sparked the escalation and the comments to the children.
Because that could sure complicate things.
And that was, yes, and that was the other reason why there was hesitation, because I mean, my client, frankly, like I said, has been at war with herself as to how to handle this, because she's trying to keep the peace. She genuinely wants to be able to get along for these children, but I'm not really sure what else she can do at this point.
No, I think if these are true, and I don't know if they are, I'm just going by what I'm hearing. And that's why I asked Mr. Shepherd, who's not being truthful, because obviously these threats are, at least alleged threats, are being made from the children. So I guess it would mean that the children are not being truthful, but we'll cross that bridge when we get to it. But I think NP, I don't represent him. You don't represent him. Nobody does.
And the father jumps back in, and he's angry. There's a history of parental alienation, he says. He accuses his ex of manipulating the kids, turning them against him, and lying about his health. He talks about anxiety, genetic factors, and emotional harm caused by introducing a new stepfather too soon. It's intense. The father sounds educated, emotional, and desperate. But under all that, you can hear one thing: fear. He's terrified of losing his kids for good.
But if these are in fact true, then he should approach the personal protection order office. But Mr. Shepherd, your thoughts, please.
Yeah, there's a lot of points to go over there. So, yeah, excuse me if I jump around a little bit. I was actually on call last night, working
Me too.
in the morning on a mental health case. So, first thing is, there's a history here of parental alienation that I originally presented to the court, but evidence wasn't allowed. They did not want me to allow me to present that. First of all, our daughter, Let me get my notes here. So first of all, our kids do have an adjustment disorder and do have anxiety, but there's a lot of factors that affect that with children. You know, our daughter has a very high genetic and environmental risk for anxiety. In fact, clinical literature shows that she has an 85 to 90, 80, between 80 and 90% chance of predispositioned anxiety because of, first of all, Jenny and I both have a history of mental health disorders with anxiety.
All right, guys, the father's going all in now. He says his ex has gaslighted their children, convincing them he's unfit to drive because of seizures he no longer has. He explains that his only seizure was years ago, medically cleared, but she keeps spreading lies. He says it's all part of her plan. She wants to ruin my life. The judge lets him talk but looks unimpressed. The longer he speaks, the more emotional it gets, but the courtroom runs on proof, not passion.
You know, when you experience multiple residential moves, you know, when your kids do have issues with learning, you know, all of these things in conjunction, you know, give you a high disposition of having anxiety. So there's a lot of other factors that affect, you know, our children's mental health that are not being, you know, discussed. You know, and then you throw in, you know, having, you know, there's.
Finally, the judge interrupts. His patience is gone. You said one more thing, and then you talked for 15 minutes. The father falls silent. You can feel the tension explode. The judge's tone is final, his authority absolute. As the father tries to defend himself one last time, the judge cuts through every excuse, focusing back on the facts, 2 alleged health episodes, child fears, and conflicting stories. The case isn't over, but one thing's clear: this courtroom war is far from finished.